I'm Marty McGarry on behalf of your host, Sierra Nevada Forum. Thank you for joining us this evening for Immigration, Fears, Fallacies, and Facts. Tonight's forum is our 34th forum in our history. 5 years ago this month, we did our very first Sierra Nevada Forum on the topic of the then brand new ACA. We want to thank our sponsors, Partnership Carson City and Nevada Humanities, for their part in our successes. And we also thank you for your donations, which help us keep the forums free for everyone. And come back next month on the second Tuesday of the month when we will present a debate on the subject of national popular vote and electoral college versus electoral college with a segment on gerrymandering and redistricting. So we have one important note for tonight. Our speaker is going to present the law. The law can be confusing in its application at times. The intended outcome for this forum is that based on a clearer understanding of immigration laws, our audience, you, will be better equipped to formulate their own informed positions related to current discussions on immigration policy. We'll have time after the speaker for questions. We ask you to write down your questions on cards such as this that we have volunteers that will pass out, and they'll collect them after you write your question. You can do that in advance if you know that you have a question you want answered, or you can do it as the presentation goes along, and then just hand them to our folks in the aisles. Also note that we tape every forum, and they can be viewed on our website, usually in about 3 weeks. So it's my pleasure now to introduce our moderator this evening, Yaraseth Anaya Lugo, the Immigration Coordinator with United Latino Community.
Tonight's presentation, Immigration, Fears, Fallacies, and Facts. As I was preparing for tonight, I've never done moderating, so I was preparing to be the best moderator you have ever seen and heard. So you can't do that without Googling. So I Googled, and I found this great speaker, not like me, this great speaker that said that in order to be a good presenter, you have to be present. So I decided I'm just going to be present. I'm not going to be scripted. I'm just going to be me. My name is Yaraseth Anaya. I've been living in this area in Carson City for the last 28 years. I have been part of United Latino ever since I came here when I was 9, and I started volunteering at the age of 9. Because when you don't have enough to do at home, they'll find you a place to put you. So that's how I ended up in United Latino. My passion is working with the Latino community. A lot of the information you're going to get today, and you can imagine how this is impacting people's lives, it's happening in our city. This is happening here. I am a Carson High School and a UNR graduate. I graduated with a political science degree, bachelor's degree, and a minor in psych because I needed the help. Today, Sierra's Nevada Forum is giving us the opportunity to be educated. It's giving us the opportunity to understand the law. The immigration law is very complex, it's very difficult to navigate, so we have an expert here to teach us how it currently is. The mission of the Sierra Nevada Forum is to provide citizens with fact-based, verifiable information. And to assist us with that verifiable information, I'm going to introduce Sylvia Ontaneda-Bernalies. You all have to repeat that, okay? Mrs. Ontaneda-Bernalies is an immigration attorney. She practices in Reno, Nevada, and she services, well, I gotta tell you her credentials. She is an attorney licensed in Maryland and Washington, D.C. She offers her legal services to local, national, and international clients, offering a variety of services, such as relative petitions, naturalization filings, and employment authorizations for foreign nationals. Today she will present us with a bird's eye view of the immigration system. She will talk about the executive orders, the different types of visas available and its complexities, family reunification versus chain migration, and diversity visas that we all hear about. I know that today's topic will bring a number of questions from you. I want to let you know that we will try to answer as many as we can with the time that we have. Thank you for coming, and let's welcome Mrs. Ontaneda-Bernalies.
Thank you. I cannot see you very well. I want to thank Marty McGarry for inviting me to speak tonight. I want to also thank you, the Sierra Nevada Forums, for holding this event. And I want to thank you for being present, for being here. I hope to impart some information to you that is helpful to understand the current debate on immigration. As you've heard, my name is Sylvia, and if you can say supercalifragilisticexpialidocious, you can say my last name. Ontaneda-Bernalies. I always have to tell people file it under O, please, because I have so many aliases. They chop my last name. I'm an immigrant. Can you hear me if I do this? Is it better? Is it better? Okay. I'm an immigrant, but I'm one of the lucky ones. I didn't have to come to the United States. I was being educated in Peru. I was going to college there in journalism, a Catholic university. I finished my studies, and I happened to be an American for whom I worked, a renowned writer and explorer of the jungles of Peru. And after many years in Peru, he decided to come back to his own country. He was born in Washington State. We sojourned in Mexico City. Our oldest son was born there, proudly a Mexican himself, a Peruvian as well, and an American. I have two other children born in Reno, Nevada. They're proud Americans, but they are also proud of their Latino heritage, even if they don't appear to be Latino by the way they look. So I was lucky. I didn't have to cross a border. I didn't have to come on a boat. I didn't have to endanger my life. And I never thought about the immigrants. I was one, but I never thought about it. I never thought about discrimination against immigrants, even though many years later, as a matter of fact, just a couple of years ago, I learned that in my neighborhood in Southwest Reno, when my husband and I bought a home there, he received a letter telling him that the neighborhood was for only whites. He kept that a secret from me. He shared it with my children many years later, and as I said, I just learned about it only a couple of years ago. So I went to college here again through personal circumstances. I started all over from undergraduate through master's degree. And then I decided to go to law school because, of course, I wasn't done with academia. Yeah, I was 52 or so. And I was going to do a PhD in social psychology and law, but I didn't want to leave Reno, and my daughter was not yet 21. And I was debating then what to do because the director of the psychology department at UNR said, well, Sylvia, you know, we don't have the program you want. I don't know that you want to be a scholar and be surrounded by books and, you know, papers and so forth. Get out of my office and go do something else. And he was right. Even though I've taught a university, I didn't want to be like that kind of a person, you know, a scholar, buried in books and so forth. So I kept talking about the law. And one of my friends went to law school at McGeorge, and I said to myself, okay, Sylvia, either do it or just shut up and stop talking about it. And in private and secretively, I applied to many law schools across the United States, and I was accepted to several. And I decided to go to George Washington University. When I was ready to go, my daughter turned 21, and at her birthday celebration, I announced that I was going to study law school, and my children, all three of them, went like, what? So I went to the capital. I fell in love with DC, didn't go visit any other schools, and stay there to study law. Again, no thought of immigrants. As a matter of fact, there was a clinic, an immigration clinic there, And I steered away from it as far as I could. That, criminal law and family law were something I was not interested in. I thought I would probably practice broadcasting. And I did an internship at the FCC. But no, I didn't. As luck would have it, I ended up working after many tries and trials and tribulations. I ended up at a firm in Baltimore. And this large firm, the oldest in Baltimore City, had one immigration attorney, whom I knew. He'd been there practicing immigration for 30 years. I was doing other things. I was doing complex litigation, you know. I was doing big stuff. And one day he knocks at my door in my office and he says, "Sylvia, I need you." I was the only Spanish-speaking attorney there. And I said, "Yes." And he says, "I have this client. He only speaks Spanish. I don't understand him. I need you to help me." So he explained what the situation was, and I said, "Listen, Jeffrey, I've never done immigration law. I have no idea what to do with this." And he says, "Guess what? I've never done this part of immigration law, so there you go. Go do what you can." And that's how I was, you know, immersed suddenly into immigration law. I fell in love with it. I fell in love with the people that immigration attorneys help. Foreigners who want to come to the United States to work, and others who are escaping terrible circumstances in their own countries. And they want freedom, they want peace of mind, they want safety. And so they come to the United States by any means possible to share in this dream that we all experience in this wonderful country, which is the United States of America. So here I am, an immigration attorney, speaking to you both from experience as an attorney and also from experience as an immigrant and from my interactions with other immigrants. Today, as has been told to you, I'm not going to give you my opinion, although it may be, you may see it here and there, okay? I'm going to try to give you a foundation about what is it that attorneys and also immigrants have to face in terms of dealing with this system that is immigration. It is a long, long presentation. Some of it is very dry. I do not know if I'm going to be able to cover everything I want to tell you today, but I'm going to do my best to give you the most information I can, okay? So having said that, by a show of hands, please let me know how many of you has a good understanding of immigration or a fair understanding of immigration, either because you have studied it, you have advocated for immigrants, or you are an immigrant yourself who has been impacted by immigration. Okay, here we go, about half a dozen or so individuals. All right. So for some of you, I'm not going to be telling you anything new, and for most of you, perhaps I will be telling you something that you've never heard before. Okay, so let's begin. As I'm going to try to deal with this doohickey here. And this one over here at the same time. Let's see if we can do this. Okay, let's see. So this presentation has been publicized as dealing with fears, fallacies, and facts. Fears. Immigration has been so controversial in America ever since the Republic was formed. Americans, for the most part, are very welcoming. But there's something about the ethos that allows for fear of the other. And sometimes that fear of the other can extend to the extreme, which is xenophobia. At the heart of every immigration controversy lies fear. Okay, I think I'm going too fast here. There we go. Now, the real problem with immigrants now, and always has been, is fear that these outsiders will overwhelm and undermine the unique way of life that makes America great. Now, you will see, as you can see there, somebody very famous said, "Why should Pennsylvania, founded by the English, become a colony of aliens who will shortly be so numerous as to Germanize us instead of our Anglifying them, and will never adopt our language, our customs, any more than they can acquire our complexion?" I bet you never heard that one before. And that was our dear Benjamin Franklin. Other people have said things like, "It is impossible that such an influx can fail to produce material effects upon the institutions of this country as it is doing upon the population. The mental and moral defects of men of such a totally alien, if not repugnant character and genius as to raise a doubt whether they will in the present or the succeeding generation become assimilated in customs and ideals to the people of this country." Okay, 1905. 1905. So let's look at some facts. The constitutional authority. Who has authority in the United States of America to control immigration, to legislate immigration? The U.S. Constitution, Article 1, Section 8, Clause 4, gives a general prescription. It commands for uniformity in terms of establishing a uniform rule of naturalization. So if you want to become a citizen by naturalization, there should be a uniform rule. But it doesn't say much more than that. It says that Congress is responsible for crafting the laws that determine how and when non-citizens can become naturalized U.S. citizens. It doesn't say whether Congress should rule about when they can come into the country, or how long they should stay. Only that the naturalization process should be uniform. Now, in the beginning, in the first 100 years of the Republic, several states passed laws. They felt free to do so, to prevent certain populations from entering the borders of their states. This is not working. There we go. Okay? And so they prevented certain populations from entering their borders. Individuals with criminal records and people who would rely on public assistance, slaves, and free blacks. That was the beginning. From 1976 to the early 1800s, forgive me for this back and forth, but I cannot see here behind me. There was an open border policy, free immigration for the most part. But from 1790 to 2006, Congress passed 43 major pieces of legislation to regulate immigration. The first one was the Alien Naturalization Act of 1790. Okay? And naturalization was limited to free white persons of good moral character. The concept of good moral character, carries on even today. There were unpopular acts like the Alien and Sedition Act of 1798. In 1850, the Know Nothing Party emerged, It sought to purify the nation by restricting immigration and altering citizenship requirements. It lasted less than 10 years, that party, thank goodness. There's the 1870 and 1882 Naturalization Acts. The last one prohibits prostitutes, convicts, idiots, lunatics, the feeble-minded, the insane, paupers, epileptics, and persons likely to become public charge. Then there was the Chinese Exclusion Act of 1882. And this is an interesting piece of legislation because after bringing Chinese people here, following, of course, the freeing of the black slaves, to work as indentured servants in the railroads and such, suddenly they were not welcome anymore. And so the Chinese Exclusion Act of 1882 places a 10-year suspension of Chinese labor immigration. Those who were already here could only stay here on a temporary basis. Students, teachers, and merchants who would come to the United States out of curiosity, read tourists, were allowed. And it provided for the deportation of Chinese who were illegally here. But the Chinese could not be naturalized. Now, the United States Supreme Court, up until about that time, the time between 1849 and 1889, did not say much about who should control immigration or what entity in the government should control immigration. But in that period, between 1849 and 1889, it begins to uphold congressional immigration laws and executive enforcement. And even though these acts were patently discriminatory in nature and the immigrants were not, did not have the right to due process. So the High Court consistently posited that this federal power flowed from the government's prerogative to control foreign affairs. So now remember what I said originally about the uniformity of naturalization regulations? Now we're talking about foreign affairs. It's the switch, right? Now we are adding a new component, a new factor into immigration legislation. And that is based on what? On the fact that the government can rule and regulate foreign affairs. So as long as it can do that, of course, it will now have the power to rule every aspect of immigration. Okay, so there were several immigration acts that put a tax per head on immigrants. And states like New York also put a tax on immigrants' heads. And in 1876, the Supreme Court struck down a New York state statute that was taxing immigrants coming in into the state on vessels. Between 1880 and 1900, that's the late 19th century, Congress begins to actively regulate immigration. The Supreme Court continues articulating clear limits on state immigration powers. And in 1898, the Supreme Court confirms that the 14th Amendment confers citizenship to all persons born in the United States. Now, until that time, blacks and the children of Chinese were not citizens. But with that Supreme Court decision, citizenship was expanded to include every person born in the United States. The Immigration Act of 1891 expands excludable classes. Now we have polygamists, The concept of crimes of moral turpitude comes into the picture, and those suffering from loathsome or contagious diseases are not welcome. You may remember a few years back the controversy of HIV infected individuals, whether they could come to the United States or whether they couldn't. And so that debate, so recent for some of us, was based on this notion that people suffering from loathsome and contagious diseases could not come to the United States. About that time, Congress establishes the first federal administrative agency to regulate immigration. Okay, and in 1892, Ellis Island is set up to regulate immigration as well. Okay, bear with me. This is going to take longer than I thought. Just trying to get. Okay, so we have the Naturalization Act of 1906, which framed the fundamental rules governing naturalization for most of the 20th century. It created the Federal Naturalization Service to oversee the nation's courts dealing with naturalization, standardized naturalization forms, and encourage state and local courts to give up naturalization jurisdiction to federal courts. Remember that I said earlier that nobody knew who controlled immigration in the beginning, and states were passing statutes and rules and regulations controlling immigrants, putting taxes on their heads and so forth, and whether they could come in or not. And as Congress tried to assert its authority over the matter, the United States Supreme Court was assisting with that, with its rulings, confirming that indeed the federal government was the one that had complete authority of immigration. This is a nice one for us women here. Expatriation Act of 1907. So we Americans, or at least American-born women who were married to foreigners, lost their American citizenship. Nice, huh? Okay. So, yeah. All right. In 1921 through 1927, Congress starts to pass regulations setting up quotas. Okay, so how many immigrants from X country can come in, or how many visas in general are we going to allow to set up for everybody, you know, and we're going to distribute little pieces of those hundreds of thousands of available visas to a country here and to a country there, and so forth, and on what basis. During that period as well, non-whites, Japanese, Indians are not eligible for citizenship, and by Indians I mean East Indians. About that time also, it's calculated that there are perhaps 1 million unauthorized Mexicans. And the numerical restrictions become entrenched in the system. Okay. Then we have 1946 I'm going to skip some of these slides because it's going to go slow. 1946 through 1964, we have a major piece of legislation, and that's the Immigration and Nationality Act of 1952. This is the basis for today's immigration law. From this body stems all the regulations, all the rules, all the decisions that are made on immigration as amended. And there are several amendments that have come down the pike since 1952, of course. Okay. It organized, codified, and modified existing immigration statutes into one body of law. Now we have everything in one place. Attorneys and politicians and legislators can go and look at the history of immigration and base their decisions on whether to tweak this or tweak that or change this or delete that by studying that body of law. So it was enacted over the veto of President Truman. He didn't like that particular piece of legislation. And it's, as I said, it still governs immigration law today. 1954, Ellis Island closes, and under Eisenhower, Operation Wetback begins. Does anybody know what Operation Wetback might have been? Yes? That's correct. Yeah, that's correct. So Operation Wetback, a very nasty term. Yes, getting rid of Mexicans, particularly. But in 1964, only a decade later, the Bracero program ends as well. And it had lasted 22 years. And the Bracero program, ironically, attempted to bring millions of Mexicans into the country. For what purpose? As labor, as cheap labor in the farms, in agriculture. Okay? And there was an arrangement, an agreement. The Mexican government didn't like it at all in the beginning. But back and forth diplomacy, and then eventually they signed up an agreement and allowed for about 5 million Mexicans to come into the country and be distributed throughout several different states where they were needed. And after they were needed, of course, you know, Operation Wetback. It makes sense, right? I told you my opinion would be there somewhere. Warned, you were warned. All right. So, okay, so let me go back one slide here, a couple of slides, actually. I should push the other button. Okay, here we go. Very important, very important. Roosevelt's Executive Order 9066 of 1942 institutes Japanese-American internment camps. And the United States Supreme Court justifies that executive order in two cases that I studied in law, and I was flabbergasted. Well, that was my first introduction to this shameful period in our American history. I was flabbergasted. Hirabayashi v. United States and Korematsu v. United States. And the United States Supreme Court says that Roosevelt's Executive Order 9066 it was justified. So it goes. Okay. Let's see. We talked about it. Okay. So then in 1976, think about it. When? Why did we wait so long to repeal that nasty executive order? What was the political reason, the policy reason to keep it in the books? I have no idea. Okay, let's move on. Okay, 1986 through 1988, we have very, very strong immigration acts. Immigration Reform and Control Act, IRCA, of 1986. It legalized, remember the word amnesty? It legalized 2.7 million aliens, I'll use that word, we'll explain it later, and who entered before January 1st of 1982. But it also created an employer sanction system because we were already experiencing the effects of unauthorized immigration. And people were up in arms as to Why are all these people here? And so forth. Let me just make a side note about the Bracero program. So the Bracero program allowed for all these Mexican, 5 million of them or so, to come into the country to be agricultural workers and allow them to be here and go back to their home. And they could come back in and then go back to their home. And so they were happy. They made money during the season they were needed, and then they would go home. But when the Bracero program ended in 1964, half of those Bracero participants were in Mexico. I'm saying half, I don't know how many really, but assume half. In Mexico, and the other half were here. And those who were here, what were they supposed to do? Leave their means of making a living to support their families? Or stay undocumented? And what were those who were on the other side of the border, who had been in the habit of seeing their families back and forth, going back and forth? What were they supposed to do? So that is what gives rise, actually, to the problem of unauthorized immigration, in my opinion. One more opinion shared with you. So this particular piece of legislation in 1986 creates an employer sanction system in order to control the employment of unauthorized immigrants. And then, of course, there is the Marriage Fraud Amendments of 1986, the same year, and various others. Okay. In 1990, between 1990 and 1996, we have another piece of legislation, the one that targets the armed forces. And it allows for expanded naturalization of individuals who were foreigners serving in our armed forces. And it allowed them to become naturalized citizens. It expanded the Act of 1968. This is an era that ushers increased immigration. Okay? Annual visas, remember I mentioned quotas before, the ceiling was increased to 700,000 general visas, and both for workers and family members. And it also ups the slots for refugees to 125,000. And one important concept comes into play, the concept of family unity. And so it prioritizes family unity, family reunification, okay? A very important term. It reserved annual allotments, a supermajority of visas for relatives of US citizens and lawful permanent residents. Okay? Lawful permanent residents. And it reorganized the employment-based visas, created new categories, and what else? It created a new immigrant stream through a diversity visa. That's a term you've been hearing in the news recently, the diversity visa. When was it created? Why was it created? 1990, the Immigration Act of 1990 created the diversity visa. We will be touching upon that a little later. Okay. In 1994, the unauthorized immigrant population is estimated to be 3.4 million. It could have been more. We don't know exactly. Okay. Between 1996 and 2000, we have two more very important pieces of legislation, both enacted in 1996, the Anti-Terrorism and Effective Death Penalty, and the Illegal Immigration Reform and Immigrant Responsibility Act. And the Immigrant Responsibility Act part is important because it speaks to the fact that immigrants, even legal immigrants, were denied most forms of public assistance. So legal immigrants could access public assistance before, but because of this act, all those benefits were reduced to just a few. And of course, unauthorized immigrants who never had access to those benefits continued to not have access to those benefits, only that it was now part of an enactment from Congress. Okay? It also restricted relief from deportation. In other words, if you could fight your deportation, and you had many different reasons why you could fight your deportation, those reasons were diminished. Okay? Now you didn't have as many. In 2000, we have the Life Act, the Legal Immigration Family Equity Act, that allows for certain immigrants, even if they had broken the law, to become lawful permanent residents through, and this section is 245I, and what that means is, and I don't explain it later, so I will explain it now. What it means is if there was a petition by a relative at some point before a certain date, okay, that would have benefited you, or if an employer had filed a petition on your behalf also before a certain date that would have benefited you, and that petition was still in the system, and it had, whether it had been adjudicated or not, approved or denied, it was sitting there, then you would pay a penalty and take advantage of the petition that you could take advantage of, whether employment or family, okay? And it's still in effect, the 245I. Many immigrants still can take advantage of that particular benefit. Okay? So with the wars that we have, the Vietnam and the Korean Wars, then those immigrants who could bring POWs or MIIs, or who could tell where they were, or could lead to their recovery or to bring them home, then they were also given the benefit of residence, lawful permanent residence. Okay. 2001. Now, in 2001, we all know what happened September 11, right? The horrible act in New York. And through that, and because of that, and we have in 2001 the USA Patriot Act. And it increased border security, it expanded the definition of terrorist and terrorist organization. And because of 9/11 and because of the US Patriot Act, students were now targeted and expanded the monitoring of foreign students. Okay? And then also another very important part of this is that it provided for increased interagency contact and cooperation. And by that I mean increased interagency, we mean local state agencies and federal agencies. Okay? So now this is the beginnings of the state. Remember in the beginning, states felt free to do what they wanted to do with immigration? But then Congress and the United States Supreme Court took that privilege away from them, and only the federal government had authority to control immigration. Now, because of the 9/11 tragedy, we begin to see the shaking of hands between agencies at the state level and the federal level vis-a-vis immigration. Okay? All right. In 2002, the Homeland Security Act of 2002 creates a Department of Homeland Security. So famous now because of General Kelly, of course, you know, who was the director, the secretary of that agency, and now is the chief of staff in the White House. And it created the department, various different entities under it are the United States Citizenship and Immigration Services, the USCIS, which most immigrants deal with when they present, US citizens present a petition, and immigrants present an application based on that petition. It also houses the U.S. Immigration and Customs Enforcement, ICE, for many immigrants known as La Migra. And it also houses the U.S. Customs and Border Protection, which deals with all the port of entry customs interactions. Okay? And the famous INS of before was, of course, abolished. Okay, in 2005, between 2005 and 2010, already into the Obama era, prior and into the Obama era, we have the Real ID Act. It broadens the definition of terrorism. It restructures the process for judicial review of immigrant decisions. And what that means really is, before, immigration judges had great discretion on what to do with immigrants who were called to their courts to appear before them because they had been charged with some immigration issue and were there on a removal proceedings. And immigration judges had great discretion based on the law, but their discretion was wide and broad. And this Real ID starts to take away that authority from immigration judges. Okay? I'm not going to go into every little detail because we would be here like a week. Okay? But trust me, and much to the chagrin of immigration judges, because they felt, as I know many judges that I've met, very passionate about the work that they do with immigrants. And eliminated general habeas jurisdiction. That's, mumbo jumbo, legal mumbo jumbo for some of us. And what it means is that during an appeal on an immigration issue, once the decision has been made for deportation removal, I say deportation/removal, the individual affected no longer has a habeas option. Once the decision is made, there's no other recourse, so goodbye, you're gone. In 2006, we have the Secure Fence Act, so famously not effective per some in Washington. And it's estimated that we have 11 million unauthorized immigrants, and supposedly about 59% of them are from Mexico. However, in 2008, there's a study that says that the unauthorized immigration has decreased to about 11.6 million. But we don't really know whether it's 12 million, 13 million, 9 million, 11 million. Everybody has kind of settled on the 11 million range there, In 2010, however, studies indicate that the inflow of unauthorized immigrants during 2007 and 2009 decreased by 2/3 from 2005 and 2002 and 2005. So there was a great increase of unauthorized immigration between 2000 and 2005. Strange, because despite 9/11 and despite the acts that were enacted in Congress as a consequence of 9/11, but unauthorized immigration increased, yet between 2007 and 2009, it decreased by 2/3. Okay. Now we are into the Obama era. Between 2012 and 2014, there are several acts of legislation. One directive, one famous directive, not an executive order, not a law passed by Congress, but a directive. And I'll explain the importance of that directive and the basis for it. And that's Deferred Action for Childhood Arrival, DACA. So controversial in the news. We do not know whether it will be totally rescinded by March 8th of this year, or 5th, I believe it is. and 700,000, 800,000, almost 900,000 beneficiaries of DACA will face deportation, or whether they won't. Okay? And if they won't, what benefits will they receive? But the Deferred Action for Childhood Arrival is not an executive order, and it is constitutional. And it's simply a directive that President Obama gave the Department of Homeland Security, the Secretary Napolitano at the time, if you may recall. And it's based on a practice already in the books called prosecutorial discretion. Prosecutorial discretion, I don't touch on it later in this presentation, but so I'll explain it now. Prosecutorial discretion has been in the books forever. Okay? What it means is that the person who is going to prosecute the case of the immigrant has the discretion to, if I present sufficient equities, that's positive factors, okay, that counter any negative factor that might be in my case, then that individual, that official, has the discretion to make a decision that's favorable to me, okay? And usually it's based on law, so the discretion is certainly a judgment, based on experience and the professionalism of the individual, but there must be some kind of legal basis under it for this official to go ahead and proceed with that discretionary decision, okay? So what happened is that President Obama directed the Secretary of Homeland Security to extend prosecutorial discretion to all these children, now some of them adults, who had been brought into the United States when they were a certain age, and through no fault of their own, because they didn't make the decision, had found themselves being undocumented and therefore deportable. And although they had made the United States, the locality in the United States, their home, and had gone to school here and knew nothing about the country that their parents had brought them from. So Obama directed the Secretary of Homeland Security to extend prosecutorial discretion and create a program that made sense, right? And it created DACA, which is the Deferred Action for Childhood Arrival. So much for that. So then we also have the Violence Against Women Reauthorization Act of 2013. Now, immigrant women who are battered by their spouses were not protected by the law, except the local, of course, state law, right? But the federal government didn't have a law that protected women who were battered by their spouses or living partner. So the Violence Against Women Act had extended that protection to immigrant women. But then it was kind of sort of rescinded. And through some good lobbying in Washington, it was reauthorized. The government reauthorized it to 2013. About violence against women in the immigrant community, if you're a lawful permanent resident, of course you are protected, right? But if you're an undocumented woman who is being battered by your spouse, you were up the creek. You have no protection whatsoever. Well, this VAWA, as we call it, extends to them, but only if the perpetrator is your United States citizen spouse, okay, or a lawful permanent resident spouse. If the perpetrator is another undocumented individual, you continue to be up the creek. You are not protected. Okay? So, now of course we have two pieces of two proposals that President Obama presented that have remained in limbo and will continue to remain in limbo for as long as, of course, the new administration is in power or any other administration that resembles the current administration. And those are the deferred action for parents of Americans and lawful permanent residents, in short called DAPA. Okay? And the other one, of course, that is a moot point right now is the expanded DACA. And the expanded DACA increased the age bracket and tweaked it a little bit more so that more people were, would fall under that umbrella. And through some legal action in Texas, it was blocked. Both of them were blocked, and now both of them are a moot point because, as I said, doubtful that the DAPA would ever even see the light of day. And the extended DACA, of course, is going to be resolved. However, it's going to be resolved by March, next March. Okay. I don't know how this is looking for the video, but I keep turning my head over there. I apologize. Okay, so now we have the directive, the presidential directive to create DACA, but how, other than comprehensive immigration reform or any kind of other immigration act enacted by Congress, how else can we impact immigration through, regulations officially? And either take away pieces or add pieces or change pieces of the law. And that is what I call legislation by other means, and that the current president has made ample use of the executive order, of course, which is in his right as president of the United States to do. And but before him, and I'm going to talk about a couple of executive orders that saw the light of day, and that was President Roosevelt's Executive Order 8802, which created the Bracero program. As I said, it was a farm labor, it's called the Emergency Farm Labor Supply Program Agreement of July 23rd, 1942. Okay, and then we have also the Executive Order, which I've already mentioned, 1966 of 1942, the infamous one that created the internment camps, and it was repealed 34 years later. And in 2001, we have an executive order that establishes the Office of Homeland Security, which grew into the Department of Homeland Security, where 22 federal agencies were merged under it. I'm going to read this. You can all read it yourselves as well. Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. And that's section 212F of the INA, which is the body of law that controls immigration. So, based on that, President Trump has issued some executive orders. He issued them immediately upon taking office. And January, as a matter of fact, I believe it was January 20th. I haven't put the exact date or month in my presentation, but you can look them up. I believe it was January 20th. Executive Order 13767, Border Security and Immigration Enforcement Improvements. 13768, Enhancing Public Safety in the Interior of the United States. I'm not going to go through the details. Okay. Then we have Order 13769, and this we know about because of the news and how controversial it was, and the legal action that ensued. called Protecting the Nation from Foreign Terrorist Entry into the United States. And it's known as the Muslim ban or the travel ban. Okay? And it went into effect January 27, March 16th. It lowered the number of refugees. Remember I said we had 125,000, give or take, from the very beginning when the quota was established. And now that reduced it to 50,000. It suspended a program for refugees and suspended entry of people from Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. And more than 700 people were detained on the basis of this particular executive order. And 60,000 visas were provisionally revoked. However, many courts blocked this particular executive order. And a temporary restraining order was issued, and which was upheld by the U.S. Court of Appeals for the Ninth Circuit, under which Nevada and California fall. And so therefore the Department of Homeland Security had to stop enforcing portions of the order and revalidated visas that had been previously revoked. Okay, then we have Executive Order 13780, Protecting the Nation from Foreign Terrorist Entry into the United States. This was, it placed limits on travel from certain countries. It was, I believe I'm repeating myself here, motivated by anti-Muslim sentiment, and the TRO was converted, the temporary restraining order was converted into an indefinite preliminary injunction. Why am I repeating myself with this particular executive order? And that's because by the presidential proclamation for 9645 of about the same period of time in 2017, it expands and defines that particular order, okay? And restricts travel from Chad. Chad was not in the first list of countries I mentioned. Chad, Iran, Libya, North Korea added to it. Somalia, Syria, adds Venezuela, and continues, of course, to include Yemen as well. And the interesting part about this executive order and the presidential proclamation is that now the United States Supreme Court allows the ban to go into full effect pending legal challenges. So for all intents and purposes, the executive order plus the presidential proclamation are kind of nowhere. They're staying put, okay? They're not supposed to act on them. They're not supposed to execute the order. So says the United States Supreme Court. Okay? But we know from experience, and I cannot give you data, and I cannot give you, I could give you anecdotal information, but it would be the same anecdotal information that you probably read in the news. But we know from the anecdotal information and from experience as an attorney, talking to other attorneys and reading all the documentation that I read on a regular basis, that parts of all those executive orders that have been stayed by the courts, in other words, don't act on them, don't execute them, says Supreme Court, and they have actually been put into effect, practically, in the streets, by the agents of the United States immigration system. Okay? So, we know how policy is enacted, how it's created. I'm probably preaching to the choir at this point because you all probably know this. And that is the executive branch, tells the legislature or establishes a communication with legislators for an agenda, items, issues that they want to see legislated upon. The legislative branch acts or doesn't act on that, or it has its own issues that it wants to legislate upon. And then once the act, of course, is executed and enacted, after much back and forth between the House and the Senate and so forth, then it becomes law, and the judiciary branch, the one that rules whether it's constitutional or whether it isn't, and it deals with all of the issues that may arise from those acts up the different courts all the way to the Supreme Court. So major immigration policies must go through this entire process, and it takes a long time. It takes a long time. We know this because comprehensive immigration reform has been debated ad nauseum for decades, right? So let's talk a little bit more about the DACA program. So we have the DACA program that was announced June 15, 2012, and it was a discretionary determination. Remember, prosecutorial discretion, I mentioned that before, to defer removal action of any individual. It does not, however, confer lawful status, and many of you already know this. If you benefited and applied for DACA, you knew what you were getting into, right? DACA doesn't confer any immigration benefit whatsoever other than deferment of deportation, meaning for the time being, for the 2 years that you have that benefit, no one is going to deport you, okay? But added to that, you are able now to work because you can apply for employment authorization. And that's a big deal. You can work, you can go to school, so colleges and universities can now accept you, and probably not charge you out of state tuition, but in-state tuition. And as long as you don't run afoul of the law, you are fine. And one more thing about DACA. What DACA did was also that the DACA recipient's family, even though they didn't derive any direct benefits from DACA itself, the mere fact that there was a DACA recipient in the household, that family was not going to be targeted by ICE, by the enforcement branch of the immigration system. So, not only was the DACA recipient safe from deportation, but his or her family as well if there were any undocumented individuals in that household, okay? And this was just simple knowledge and it made sense and logical, right? It granted the individual so it stopped the clock. In other words, any accruing unlawful presence was stopped. As long as you were under DACA, you were not accruing unlawful presence, okay? So if you were 18 years of age when you got DACA, and you continued with the program 2 years, and then you renewed another 2 years, and then you renewed another 2 years, those 2, 4, or 6 years were not added to your unlawful presence, okay? All right, let's move on here. So you all know what the requirements were for DACA eligibility. You had to be 16 years of age or younger. You had to be 15 years old at the time that you applied for DACA. You arrived 16 years of age or younger. You were not in removal proceedings. You could be up to 31 years of age. And you were physically present, and you had no lawful status, and you had continuous residence in the United States. And one more important thing is that you had to be enrolled in high school, or have a high school diploma, or be enrolled in a GED program, or have attained a GED equivalent diploma. You could be in the Coast Guard, the Armed Forces with honorable discharge, and not convicted of any crime, no criminal offense, felony offenses, or significant misdemeanor offense, or multiple misdemeanor offenses. You did not pose a threat to national security or public safety, so you were vetted. DACA recipients are thoroughly vetted. Okay? There are several youngsters that have come to me, and I add this to the presentation, that I would ask, have you ever used a social security number? And they would look at me like they were caught, in the headlights. Oops. And I said, did you? And they'd say, yeah. Well, how did you acquire that social security number? So-and-so gave it to me. Whose social security number was it? I don't know. So that would have been an issue, because if the social security belonged to somebody really, a real person, it wasn't invented, okay? If it really belonged to a real person, that is a problem, because you are taking on the identity of that other individual, right? But if you committed that problem when you were younger than 16, the system was very lenient. If you were older, 18, 20, 21, then you would have issues, okay? So we attorneys would have to really be sure, completely sure, that our client who was intending to apply for DACA did not have anything that would mar the record, including having had a social security. Because youngsters go to work, they go to work at McDonald's or wherever, and they need identification. Okay, so I'm being told that we don't have much time left. So I'm going to move on. The DACA rescission, you know what happened. In June of last year, it was announced that it would be rescinded. And Jeff Sessions repealed it in September, saying that DACA-eligible individuals are lawbreakers. They negatively impact wages and the employment of native-born Americans, and so forth. Okay. So look at the history of the DREAM Act. Remember the famous DREAM Act? Everybody wants a DREAM Act. The DREAM Act is nothing more than a proposal for legislation that would protect all these youngsters, 31 years of all age and younger. Okay? Since 2003, my dear people, we've been on this, about the DREAM Act, until now. Okay? Now, the DREAM Act hasn't gone anywhere. DACA has been rescinded temporarily. And there are various different proposals up there in Congress. Okay? Recognizing Americans' Children Act, the American Hope Act, the Bridge Act. Some of them are good, some of them are really bad. We have the most recent one is by McCain and Coons, the USA Act. Okay? So I'm going to go very quickly now because it seems like I don't have much time, although I was told that I could have half an hour more. Yes? Or am I into the half hour already? Okay. So what's the bureaucratic apparatus? Here it is, the administrative structure. There's a Department of Homeland Security, the Department of Justice, the Department of Labor, the Department of State, the Department of Health, the federal courts. All of that apparatus handles and deals with immigration. Department of Homeland Security regulates. The Department of Justice as the legal branch, so all cases would climb up the ladder all the way up to the Department of Justice, and then all the way through the federal courts to the Supreme Court. The Supreme Court hears very, very few immigration cases, very few. Okay? Then there's the Department of Labor. The Department of Labor basically issues the visas, okay, and handles all the embassy and consulate activities with the foreigners in the foreigners' country of origin. Okay? And the Department of State, I should have said, the Department of Labor deals with all the employment issues, pardon me. Okay? So, and then here we have an attorney, like I was thrown into immigration. Just go swim, there's no water, don't worry about it, you'll be fine. Okay, so I had to go to immigration sources, right? Statutes, regulations, decisions, the INA, the main law, international law having to do with that too, and so forth. Okay, so the largest immigration system in the world is where? In the United States. Approximate annual numbers, 10 million or more non-immigrants come through our doors. Usually in the neighborhood of 1 million new immigrants into the United States and about 1 million or more international students. Okay? So very quickly, this is not working. Okay, so who is a native born? Anyone who is born a U.S. citizen at birth, right? Anyone. So they could be born where? In the United States, on our soil. They could be born in Puerto Rico, in any island that we control, like Guam, the Marianas. It could be born abroad in Europe or in China, in Peru, my country, born of U.S. citizen parents. However, it is not automatic unless you register with the American consulate. You may miss that point after they are 2.5 years or 3 years of age. You have to battle it again, like any other immigrant. Okay? So sometimes, in some instances, you can get United States citizenship through a grandparent, and that's a little tidbit that a lot of people don't know. It's not common, but it can be done. You have to meet certain requirements. So a foreign-born is anyone, of course, who is a United States citizen by naturalization, like me. Okay? Lawful permanent residents, temporary migrants, humanitarian migrants, and authorized migrants. Okay? So a citizen sworns loyalty to a nation. I'm a citizen, I sworn loyalty to the Constitution and to the United States through my naturalization. And I have to prove certain, this is not working for you guys. Okay, I'm just going to go through this. So, whoever is not a citizen already is an immigrant or a non-immigrant. And you might say, well, what's the difference between an immigrant and a non-immigrant? A non-immigrant still lawful in the United States, except they are not seeking permanent residence, okay? Like temporary workers, for example. Anybody coming into the United States through some kind of work visa is a non-immigrant. Okay? Anybody coming in through a relative petition is seeking to be a permanent immigrant, an immigrant. Okay? So anybody who comes into the United States needs to prove that they have the right intent. Not just come in and then decide, oh, I'm going to apply for a job. I can come in as a tourist and then I apply for a job. It doesn't work that way. You have to actually, because the law presumes, there's called the presumption of intent or the presumption of law. The law presumes that everybody who comes into the United States intends to stay permanently and work here. That's the presumption of the law. And it's the burden of proof of the immigrant, of the would-be visitor, to prove otherwise. Okay? And you do that, of course, through documentation and so forth, and declarations and affidavits and so forth, that you have a home in your country, that you have a bank account, and that you have money, and that you have a job, and that you're coming in to visit only for a month, and you're going to go to back home after 30 days. Okay? Or that you're coming here to work for X company and you're going back after 3 years. So your intent is important. When you cross the border, when you come into the United States, that is why they ask immigrants and everybody coming through all kinds of questions, right? And so that's how you overcome the presumption. So there is the pure intent doctrine, meaning the pure intent is you intend to return to your country. However, the law also allows for dual intent. Dual intent only applies to some employment visas. And they are for people who have very high status in a company, like for example, executives. If they have a visa that allows for dual intent, they can work at their company while they are here and at the same time intend to become residents. Okay? But not every employer employs people at that level. Okay? So most employees who are foreigner must have only one intent, to return home. Okay. Okay. Is it clicking? It's not clicking. Did you click to until we got to the alien thing? Okay. So it should look like this. Let me see. Yeah, there. Yeah. Thank you. Okay, here we go. Yeah, you can be helpful. Thank you. You can watch me here. That'd be great. Okay, so look at that. Isn't that wonderful? Alien. And I've been using that term on purpose, right? I said I would use it, and I've been using it. It is written in the law. Alien. Okay? So a person not a citizen or national of the United States is an alien. We have legal alien and illegal alien. You can flick it. Are not official terms. They are not official terms. The term legal alien was coined in 1798 from the Alien and Sedition Act, that Unpopular Act I mentioned earlier. Okay? So we keep using it, though. It sounds so bad, doesn't it? All right. So what about undocumented immigrant? Or illegal immigrant, as often we hear people refer to others. There's no such thing as an illegal immigrant. No? Not even an illegal alien, as I just said. Undocumented immigrant was coined in 2004 by the Government Accountability Office, and it referred to an undocumented alien. Okay? So anybody who is in the United States with a visa is a legal alien of some sort. But anybody who is in the United States who came through the borders or any other way without being inspected by a customs agent and entered without inspection, we call them EWIs in the law and the practice, E-W-I, EWIs. They entered without inspection. That's as far as we know. Okay? Are we good?
No. 7:30.
Is it 7:30? Okay, I can stop there and answer questions, or I can go on and bore you some more.
I do have a few questions.
Okay.
And I think to move this along, can you tell us how can people right now, what's the law, who can become eligible?
Okay. So let's say that one of you who is single here marries a foreign-born individual, and that foreign-born individual is in that person's country, is residing in, let's say, Ethiopia, okay? And now you want to bring that foreign person here because you went to Ethiopia, you fell in love, you live there, and you marry that person, right? So you petition the government with a certain form, you petition to establish the legality of your relationship. You say to the government, let me show you, I'm legally married to this person, and here's the proof that we have a bona fide marriage, bona fide, in good faith. That that person is not seeking an immigration benefit through marriage, which would be fraud. We actually have had a relationship, and here's the proof, okay? We were boyfriend, girlfriend, we got engaged, we had a ceremony of engagement, we got married, there was a ceremony for our marriage, there was a reception, here are the photos, here are phone calls, here are texts, here are emails. And not only that, but I have a life insurance and she's the beneficiary. And when she comes here to the United States, I intend to add her to the title for my home. And I have the money to bring her, you know. And then when that petition is approved, okay, then the would-be beneficiary, the spouse, needs to apply through a different form, and that form tells the government and says, listen, government of the United States, based on the petition from my spouse, that's my legal basis, I am applying and asking you, government, to grant me a visa, okay, a green card. And then the government, and here is the document and the form proving that my spouse can support me. And taxes and bank accounts and all kinds of things are presented, okay? And so the government says, oh, okay, everything looks good. You know, remember bureaucratic agents, okay? They then approve that application. First phase petition, second phase application, okay? However, if the person is on the other side of the pond, it's abroad, that second phase of the process goes through what's called consular processing. And you do the same thing of proving all that I just explained, but it goes through the consulate or the embassy, okay? If, however, the person is in the United States, she or he was studying here, had a visa, so it was lawful status, okay? And then you married, you have to prove the same thing, prove the relationship through the petition, and now the foreign spouse applies through a different form and proves exactly what I just explained, okay? And then the government looks at that, they call them in for an interview, and they ask them questions. They even ask them questions as to what side of the bathroom basin does your husband keep the toothbrush? Oh yes, oh yes. Forgive me for saying this, but just very recently one of my clients was asked about their sexual practices and frequencies. I will tell you why. Why does the government want to know during that interview? Some interviews don't go that deep. Some interviews are, you know, quick. But some interviews can be very, very detailed. Why? Because they want to prevent what? Marriage fraud. Marriage fraud. Okay?
I have a question here. What benefits, what public benefits can an undocumented immigrant be eligible for?
None. Zero. Zilch. Zero. However, if they go to the emergency, they do. However, if they are pregnant, they may get some benefits, some of the programs that help pregnant women, right? Because why? Because that child is what? Going to be what? A United States citizen. And then when the child is born is what? A United States citizen. And if they need some of those benefits, you know, then the child is getting a chip, Medicaid, not the parent, the child, United States citizen, okay?
How long can you be in the U.S. and still be eligible for naturalization?
Well, as long as as long as you are in lawful status, remember that, lawful status, and you have a green card, which is you are a lawful permanent resident, no one else can become a citizen. The only people who can become a citizen, so there's no jumping. Like some people will say, well, why didn't they get their citizenship? Why are they still undocumented? Right? Because who can only become citizens? A lawful permanent resident. And that permanent resident jumped through the hoops to get what? What we call a green card. Okay? And if that lawful permanent resident, LPR as we call them for short, if the LPR is married to a US citizen, they have 3 years. And after 3 years, they can apply for citizenship. If the LPR is through employment, remember the exception, the dual intent thing I talked about? Okay, if that is through employment, they have 5 years. Okay? 5 years. If the LPR is the brother, sister, or married child, adult child of a US citizen, that LPR also has 5 years to become a citizen. However, you said how long can you be in the United States? That's the question. You can be here your entire life and not become a citizen. You continue to be eligible only if you continue to maintain your lawful permanent residence. How do you maintain your lawful permanent residence? Oh, I'm going to go to my country, to Ecuador, I'm already a resident of the United States, I am going to go to Ecuador, back to my roots and stay there for a year. Can you do that?
No.
No. You could go up to 180 days. You could go out of the country for up to 180 days and then come back. The first time, the government doesn't say a thing. The next time, another 180 days. And then the third time, the government might say to you, and by government I mean the customs agent at the port of entry. And they say, listen, Missy, you got a green card. You've been to Ecuador for 6 months in 2016 and 15. And in 2016, you also were there for 6 months. And in 2017, you have been there for another 6 months, and you are coming and you are intending to re-enter. Because every time a lawful permanent resident leaves the United States, they are actually petitioned, when they come in, they're actually petitioning the government to be allowed to re-enter. That's something most LPRs don't realize. They are petitioning the government to re-enter. But after 3 of these little, excursions to Ecuador of 6 months, the government is going to say to you, whoa, 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 whoa. Do you really want to continue to be a resident of the United States? Or would you prefer to just go back to your country of Ecuador and stay there? You see? So, there are people here who are LPRs, 20, 30, 40 years. Of course, they don't do these saunters to their country. They don't have the means. Can I add something to that? Yes? May I add something to that answer? Okay. What's the benefit of US citizenship? Nobody can take it away from you. You were born here, wonderful. Nobody can tell you you are no longer a United States citizen. Nobody can, if you were born here. If you are naturalized United States citizen, nobody can tell you you're not. We don't, no. We want to revoke your citizenship through naturalization. Not like that. If you have been born here, you can go to your Department of State and through a particular process say, I don't want to be a United States citizen anymore. Sign on a particular form on the dotted line and swear that you indeed do not want to be a United States citizen. Many people have done that, right? The same thing holds true for the naturalized individual, me. I can do that. I no longer want to be a United States citizen, but I have to go and do it under oath. The other way is if my citizenship was acquired through fraud and it can be proven, yeah, it's a long haul for the state, for the government to prove that, but it has happened and it can be done. Okay?
Can you speak on the ruling of DACA today?
I certainly can, but my opinion is going to be as good as yours. Okay? One more thing about the LPR though, before I jump into that question. The problem for the LPR individual, the lawful permanent resident, is that they can lose their green card much more easily than a naturalized person can lose their naturalization. You've seen it in the news. You've been here 30 years. You've been working as a professor. And all of a sudden, when you were 16 or 17, you committed indiscretion. And guess what? It's been in the news just in the last couple of days, right? What happened? The government went and grabbed that gentleman, and what? He was on his way on the plane, being taken out of the country. When was it? Just yesterday? And they stopped in Hawaii, and the courts ruled in his favor to stay the deportation. Stay is a legal term, to stop it. To stop the deportation process while they were in Hawaii, and now the plane has turned back to the United States to bring him back. Okay? Stays of deportation are very difficult to get. You have to have many equities, many favorable factors, fought very hard by your very good immigration attorney.
What visa categories are there, and by number of visas by country?
Oh my goodness gracious. Should I go there?
Can you repeat that?
Okay, no, it's a very fair question. It's a good question. I have it here, and you were going to see that in, if you can get to there while I talk,
Would you
that'd be
repeat
great.
the question? now?
Yes, I will repeat the question. What visa categories are there, and what are the numbers of visas by country?
Okay, all right. So, this is the universe of visas, okay? There are about 700,000 visas available in the universe of visas, according to the quotas that the government, Congress, and the Homeland Security have set. Okay? And they are allocated for different categories. Two of the main categories is employment visa and family-based visas, right? The family-based visa, there's an unlimited number. There's no wait for spouse, for child, minor child, and for parent. So if you apply for your spouse, or you apply for your parent, or you apply for your child, the only time that you're going to wait is the processing time. But the visa, at the end of the processing time, the visa is there for him or her, okay? Then you have adult children of US citizens. You have married children of US citizens. You have spouse of lawful permanent resident, minor children of lawful permanent resident. You have sibling of US citizen, okay? These preferences, as they are called, yeah, the petition is going to be approved as long as you establish the legality of the relationship. Remember I said you petition? But the visa is not there for you automatically. The only thing that's going to see the end of the process is the petition, right? But you, the sibling, the married child of your citizen, the spouse of a lawful permanent resident, the minor child of a lawful permanent resident, you have to wait. Guess why? And some of you will have to wait 10, 15, 20, 25 years. Why? Because there's only what? 700,000 visas, right? In the whole world, in the whole universe of visas for the United States. And if you come from Mexico, India, or China, as many other countries are as well, oversubscribed. What does that mean? That every year there are so many visa petitions for spouses, children, and siblings in the Philippines. And of those countries, that the particular annual allocation is consumed faster. You follow me? Yes. So, in the Philippines, my sibling probably is going to wait 20 years for a visa. Which brings me to a fallacy. We were talking about fears and fallacies, and I never got to show off my fallacies. And that is what do you call it? Chain migration. Yeah. Isn't that a neat little encapsulation of all kinds of things? Chain migration. What do you think about when you hear chain migration? That what? That the United States citizen or the lawful permanent resident has the ability to what? To bring everybody in, cousins, grandparents, aunts, uncles. Not so. Not so. Nobody can bring a grandparent in. U.S. citizen or lawful permanent, or LPR for short. No one can bring a cousin in. No one can bring an aunt or uncle. You cannot bring your in-laws directly. You cannot bring your in-laws. So where's the chain migration? Wait a minute, let me think about it. So what did I just say? Spouse, minor child, and parent get automatic visas at the end of the process, right? Right? Which can last, by the way, 6 months to 18 months or longer, depending on the complexity. Okay, so let's say that for the sake of argument, it's one of those very complex cases, and you have waited 2 years to bring your spouse here, or 2 years to bring your minor child here, or 2 years to bring your elderly parent here. Okay? The same thing true for the lawful permanent resident, who can only bring who? Spouse and minor children. Same thing. So if I want to bring my brother or my sister, okay, and I am from the Philippines, and I happen to have married an American, and he brought me here, and that was quick because I was the spouse, right? Quick, 2 years, that's quick. So now I'm here, and I am a green card holder. I begin the petition for my sister, who is 11. No? Oh, well, I beg your pardon, I'm lying because I cannot bring my sister. But let's say I want to bring my mother. Okay, my mother. And now she's in the Philippines. And I'm a green card holder. And I can petition for her. So then 3 years go by, and now I become a citizen. Remember, 3 years to become a citizen if married to a U.S. citizen? So now I tell the government, hey, government, I've switched. I am no longer an LPR. So my category for my mother doesn't apply anymore. Now the category applies because I am a naturalized citizen. I'm a citizen. And it must be faster. No, sorry. Sometimes it isn't faster. Sometimes the other way was faster. But anyhow, your country's oversubscribed. And when did you petition? When was the petition that what was the date? Oh, June 24th, 1994? Oh yeah, well, we cannot really project, but we will be publishing a visa bulletin every month, and you can check every year since 1994 when I sent that petition. Remember, I'm from the Philippines, and I filed in 1994, and I will have been looking at that monthly visa bulletin to see if there was a visa available for my mother until today, and they are just now dealing with 1994 visas for June. Okay? How about that for chain migration? How quick? Chain migration? No, 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 no. That is called a fallacy, and you know what else? Hooey. Okay? Because there's no such thing as chain migration. I know that the current president said that one of the terrorists for some kind of tragedy that occurred in one of the states, not too, oh yeah, here we go. The Manhattan truck attack, I have it. Okay, the Manhattan truck attack. He said, and I'm quoting, 22 to 24 people came in through the suspect in the Manhattan truck attack. 22 to 24. How could that happen? In what span of time? Let me tell you the reality about him. We were talking about facts, fear. What kind of fear does this, instill in you? 22 to 24 more of him in my country? How dare he, right? He's a terrorist. He just killed so many people. Fear. Fallacy. Okay? It cannot happen. I just explained to you. A U.S. citizen has trouble bringing people in, right? Unless they are father, mother, child, or spouse. So, let me tell you. This man, his name is Sayfullah Saidnov. He was a suspect of that Manhattan truck attack. He emigrated to the United States in 2010 from Uzbekistan, married another person from Uzbekistan in 2013. Who are they? Are they citizens? No, they are what? LPRs, right? Lawful permanent residents. And who can the lawful permanent resident bring? Who? Spouse and minor children. Okay, so they didn't bring anybody because they didn't have anybody to bring. They already met here and they married, right? Or he brought her or whatever, pardon me. And then they had 3 children born in the United States. Minor children, obviously between 2010 and 2013 when he married, and whenever Mr. Trump said what he said, those little children were not 21 years of age, right? Because only if you're 21 years of age can you petition the government to bring somebody in, okay? So as a green card holder, he would not have been able to sponsor any extended family, nobody, beyond the spouse, the parents, and their married children. So theoretically, had he obtained citizenship, he could have petitioned his parents, right? And 2 years later, they were here. Or his 3 sisters. But what's the allocation of visas for Uzbekistan? I don't know, but let's say it's like the Philippines, okay? And Uzbekistan is oversubscribed. And so in 2000 and 12, 13, 14, 15, whenever, he becomes a U.S. citizen and he decides immediately, because he has the funds, by the way, he has the funds to support a household now of not only himself and his wife and his 3 children, 5 people, but he now has the funds to also bring in 3 sisters and support them. He has to prove to the government he can support a household of how many? 8, right? And he's going to petition for them right away, all 3 at the same time. Okay, the attorney gave him a good deal, all right? But the government didn't, because he has to pay for each petition separately. All right. So now he petitions for them, and voila, the petition goes, everything looks beautiful because the attorney is really good. Everything looks, every I is dotted, every T is crossed. Okay, goes the petition for 3 of them. And here comes the wait. How long is the wait? Is it going to be 1 year, 2 years, 3 years, 4 years, 5 years? How many months of visa bulletins do I have to check, Is it going to be like the Philippines, 24, 25 years for siblings? So how in the world do we explain and justify the concept of chain migration. What it really is code for no more family reunification. No more family reunification. Family reunification is what? I bring my sibling, yes. We want to be a family, right? I bring my parents, that's easy. I bring my siblings. I cannot bring my grandmother, you know? I can't bring my grandmother, but I'll bring my siblings, okay? And they will bring, once they're here and are able to, they will bring, you know, their children and so forth. But it takes years to do that. Any more questions?
This is a question for Yara.
Okay.
I'll get back to DACA, don't worry about it. I haven't
I
forgotten.
can't read it.
Maybe I can.
Can you read it?
What should one say to a child who says, I do not want you in school because I don't know if my parent will be home when I get home?
Oh my goodness.
Oh my goodness. That is happening here in Carson, and I can tell you, what should I tell a child who says, I don't want to go to school because I am afraid my parents will not be home when I come back? That is happening here in Carson. It's happening in our schools.
Okay.
What we do tell our parents is, let's contact the school. They have social workers. Let's get the school involved. We try to comfort the parents. We always talk to the parents and tell them, when you're talking about this, try to not include the kids. It's very tough. We do try to find guidance, legal guidance, to see if they have any way to adjust their status through any of these visas, through the bulletin, through a sibling. But it's heartbreaking to see the parents come in with children crying.
I wish I had the answer for that. I'm not a social worker. I identify with them a lot, though. I'm not a psychologist. I studied social psychology, but that's nothing to do with psychology. It breaks my heart. What do you tell to a child who is aware that he may lose or she may lose his parent or her parent? Not to death. That's so fine, you know. But for the child, it is almost. You know, I don't know. Prepare them as best you can with social workers, with psychologists if necessary, with conversations that are honest and open, and with practical explanations, not lies, no euphemisms, real, you know, honest to goodness, good for the level of age, for the level of the child, of course, you know. A 12-year-old can process information that a 6-year-old can't, but a 6-year-old also feels this impending, you know, breakup of the family. It is really horrendous. But speaking of, and going to another fallacy, let me talk about the concept of anchor baby. Anybody heard of anchor baby? Oh yes, we've heard of anchor baby, haven't we? So the anchor baby fallacy presumes that the woman either comes in pregnant or gets pregnant right away after entering the country through unauthorized means, what we call undocumented, via the border, most commonly. And she's already plotting this, right? She's already has this in mind, oh, my baby's going to be born in the United States, and then I'm going to have US citizenship through my baby born in the United States. So, indeed, the child born in the United States, whether she plotted it or not, whether she planned it ahead of time or not, unlikely though, think about it. I'll say something to that point after I make this other point. So, anchor baby. So she comes in through the border, because that's the image we are being told to imagine, right? We're being told to imagine that the anchor baby belongs to an undocumented woman who comes from Mexico, most likely, or from Central America. That's who we are being told to imagine, to visualize. So she comes in and has the baby, and guess what? What does the United States Constitution say? Anybody born in the United States is a United States citizen. So the child is a United States citizen. And then what I just said just a moment ago, that you have to be 21 to be able to petition for a relative, right? And if you are a US citizen and you are 21, you can petition for your who? Your parent, correct? And didn't I just say that parents have immediate visas? Yeah, after the process of whatever time it takes. I did say that. However, that is the right of the US citizen to petition. And as long as he or she establishes the relationship, the maternal-paternal relationship with the parent, and the government sees that there exists a relationship through birth certificates and so forth, not marriage certificates, birth certificates, or paternal, or what do you call them, DNA test if it's a male parent somewhere. Yeah, I'm a US citizen, I can do that. But guess what? Now my mother, who is undocumented, undocumented, capitalized, underline, bold letter, okay? Undocumented. She has to do what? What did I say? That petition was the first phase. What's the second phase? The application. I like to make it very clear distinction. Petition, application. Now she has to apply for adjustment of status. What was her status up to now? Undocumented. And she presumably can now petition, apply for adjustment of status from undocumented status to what status? Lawful permanent resident. Can she do that? Oh, certainly she can fill out a form. She can answer all the questions. She'll have to be truthful, otherwise she will commit perjury. So being truthful, she doesn't want to commit perjury. She's going to tell the government that she's been in the country for how many years now? Remember, she had the child, and he or she's 21 now. How many years has she been undocumented here? Never a problem with the law. She never drove a car, she never had a traffic ticket, she never did anything wrong. She will have to tell the government that she's been in the country undocumented for X number of years, correct? Right. And guess what? The law doesn't allow for her to get a visa. The law doesn't allow for her to get permanent residency. The law doesn't allow for that. She is not entitled, even through her US citizen child. And assume that she doesn't have a child, that she's come here and undocumented, she's young, pretty, and whatnot, and some good red-blooded American looks at her and says, she's so pretty, I'm going to marry her, and they end up getting married. And everything is on the up and up. No fraud, no bona fide marriage, okay? And he's so enthusiastic, now I can change, I can help her. She's my wife, I love her, I adore her. And I'm going to petition for her. Correct? Well, same scenario. She has to apply, and she has to declare that she's been here 3, 4 years, 5 years, 6 years as an undocumented individual. And guess what? The law does not provide for her to have a visa of residency, even if she's married to a US citizen, even if she's married to a US. Saying that, they may say that I'm talking generalities. There's always an exception to something, right? So let's assume that the young couple married and they have a child, and now the little child is 5 years of age, and the little child is autistic, okay? And the mother doesn't work because she's just taking care of that autistic little child, okay? But she's undocumented. And he petitions for her, and she applies, and even though the government would otherwise deny her, as long as she can prove that she's the sole caretaker of that autistic child, she may get, and I say may because it's discretionary, may get a lawful permanent resident visa, okay? Because of undue hardship. There's a concept called undue hardship, and you have to prove it. It's a very, very high bar. You have to really work hard to prove that. Okay, so let me talk about, so you understand now what does anchor baby mean? It's another fallacy to instill what kind of fear? So I wanted to add something to this because guess what? There is such a thing as anchor baby. Oh wow, but you just said there isn't. No, there is. And you know who has anchor babies? Rich Chinese and rich Russians. Because they can afford to come here on a visa of some form. So their status is what? Legal, lawful, because they have some business visa, some kind of visa that allows them to be here for 6 months or whatever. And while they are here, because they came in, what? They came in pregnant. They came in pregnant, and there are such things. This is a business, by the way. This is a business. Google it, and you'll find out what neat business this is. It's a kind of a pregnancy tourism. Okay. And they come here, they have the child, and guess what? The child is what? A U.S. citizen. And when can the child petition for his mother or father? When he or she is 21. And since she was here lawfully, there's no issue, there's no negative factor, right, against her.
You're saying as long as that 21 years, the mother is...
Oh no, she can go back home.
Okay, then she can go back home.
And he can go back there with her. He will,
But the
like you and everybody here, you can go
The
to.
application process will deny it if you are here undocumented.
Yes.
Yeah.
Can we go back to the DACA ruling?
Yes. Yes.
The one that happened today.
What happened today? Was I out of the loop?
We must have, because I have a question here that says, can you speak on the DACA ruling today, on DACA?
Tell me, who wrote this question? You must know something that I don't know. What happened today with DACA?
Google it.
You'll have to Google it for me because I don't know. I was out of the loop today on the news.
A Brooklyn judge blocked the decision, the second judge. U.S. District Judge Nicholas something in Brooklyn blocked it, like the judge prior did.
I'm sorry, I cannot speak to that. I have no idea what we're talking about here. Now I can talk about DACA in general.
It was an
and what
injunction
we-
to keep DACA in place.
Yeah, said it can't be rescinded.
It cannot be what?
Second federal judge
Oh,
issues
oh,
injunction.
Okay, I see what you're saying. And they happened today?
Yes,
This happened today, huh? I haven't been watching the news or
Yeah,
anything.
for the second time in 2 months, a federal judge.
Yeah, we're lost. We're lost.
Well, the question is a very general question. What would I say about that? And I just said I can't say anything.
The second judge can tell the president he can't rescind DACA.
Of course he can, the judge can.
The question that we got said, can you speak on the DACA ruling today, on DACA, by Judge, I can't read the judge's name. And she's saying she can't speak to that because she has not watched the news.
I haven't read anything and I know what you know. Yeah, nothing. Okay? So unless there is another question, I'm going to wrap it up here. Yes, I'll be happy to answer any questions you have.
How can the term chain migration be used chronically with nobody in the media explaining that it's a fallacy?
Okay, this is such a good question. It is such a good question. I'm a journalist as well. I am a journalist. I have been a print journalist. I have been a radio journalist. I've been a broadcast journalist. I've been a documentarist. And I love that profession. I love it dearly. Up until now, I have never heard a journalist or read an article from a journalist that gave the impression to me that they understood what immigration was, or what the processes were, or the benefits that accrued to citizens or lawful permanent residents. And I'm saying this because of the many years, that I've been in touch with the topic. However, I must say that these last 2 months, I have heard extremely well-informed reportage on immigration on television. The most recent one I heard was from Van Jones, is his name? Van Jones, a wonderful commentator. But you bring up a point that is really a very important point. As a journalist, I'm also a consumer of news, as you all are. And we can only know the facts of an issue, as my professor said, only if you follow the issue to its ultimate consequence. And that means you have to be on top of it day by day, by day, by day. And you have to come at it from all kinds of angles. You can only live in a bubble and read only what resonates with you. You have to read everything that concerns that particular issue, pro, con, good, bad, mediocre or not, indifferent or not, right? Why? Because it is you, the citizen, the voter, who is going to ultimately make an informed decision about your position vis-a-vis that issue. And that position may end up being expressed where? At the voting booth, right, correct? How can you be well informed as a citizen on immigration if the journalist isn't? Because you're not a scholar, to begin with. You are not studying immigration as a scholar. You are not an attorney. You don't have to delve into immigration as an attorney, that you need to know all the ins and outs of the processes and so forth, right? You are not a professor of immigration. You are a citizen who is being affected by policy. And that policy is bringing people and their needs and contributions to impinge upon your life. And so how do you make an informed decision if the sources that you rely on are not informed either? Right? And so when a journalist just takes a term like chain migration and repeats it and regurgitates it without the analysis an assessment that should go tacked to that, we all lose. We all lose. Okay? So in these days, if there's anything I would like to say to you, both as an attorney who has to deal with the pain and the grief and the anxiety and the fear of countless clients who I have to go and send home without giving them any relief, because I tell them there's no relief for you, my dear. And if I were you, I wouldn't drive. You know what I mean? I would ask of you also as an immigrant. I would ask of you also as a woman. I would ask of you also as a mother. I would ask of you as a human being that you pay attention to what is being debated in Washington these days about immigrants. Because after all, we are the nation we want to be. We are the community we want to be. And if you or I do not want to have people of color or Asian individuals because they have slanted eyes, or, Middle Easterners because they wear turbans in our community, we better know exactly why that is. And if we don't care and we don't pay attention, then we will get the community that we deserve. Either way, we get the community that we deserve. I would hope with all my heart that everybody here and everybody who left and everybody that you have an influence on really understands that we are one community, one world, one people, and it doesn't matter who comes to our shores as long as they are here to contribute something and to make something better of themselves. Are there problems with everybody and everybody's community and small communities as well as in large communities? Indeed there are. Are all Peruvians upstanding individuals? No. Are all Americans upstanding individuals? No. So we deal with those issues the way we deal with them with the legal system, the penal system, the civil system, correct? We have methods and means to do that. But to then say that every DACA recipient is a criminal is to say that all the vetting that went on to give these youngsters and young people their DACA benefit was flawed and a joke. Correct?
That's a great closing remark.